Hello all, welcome to Lucid Means. Today's topic is Citizenship Amendment Bill. This topic is really important for everyone, especially for those who are going for the interview this time. So, why this topic is relevant? It is because the Lok Sabha has passed the Citizenship Amendment Bill 2019 this January, and it is in due for the consideration of Rajya Sabha. So, what is the idea behind citizenship? Citizenship is the legal right to belong to a particular country. In other words, citizenship bestows upon individuals the membership in a national political community so that citizens can enjoy civil and political rights in a sovereign state. So let's look at citizenship in India. Indian Constitution has Articles 5 to 11 which deals with Indian citizenship. Article 5 provides for citizenship by domicile. Article 6 grants citizenship to persons who migrated from Pakistan to present India before the commencement of the Constitution. Article 7 confers citizenship on those persons who migrated to Pakistan after announcement of independence but later returned back to India. Article 8 provides for citizenship for those persons whose parents or grandparents were born in India but are residents of abroad. Article 9 provides that any person who acquired the citizenship of any other country will not be entitled to the citizenship of India. Article 10 states that all citizens shall continue to be citizens of India. Article 11 confers power on Parliament to make rules regarding citizenship. So, how citizenship works in India? It is through the enactment of Citizenship Act 1955. By the virtue of Article 11 of the Constitution, Parliament has enacted this Act in 1955. The Act provides for acquisition and loss of citizenship after the commencement of the Constitution. Act has been amended a number of times, the last one being in 2003. The Act mentions ways in which a person may be Indian citizen. So the first way is citizenship by birth. A person born in India on or after the specified dates is considered a citizen of India by birth if both the parents are citizens of India or one of the parents is a citizen of India and the other is not an illegal migrant. Next, citizenship by descent. A person who is born outside India gets Indian citizenship if he or she has an Indian father and if his or her birth is registered within 1 year. Next is citizenship by registration. Subject to certain conditions and restrictions, a person of Indian origin or a woman married to Indian citizen can be registered as Indian citizen. Fourth one is citizenship by naturalization. Citizenship of India by naturalization can be acquired by a foreigner who have resided in India during the last 12 months and for 11 of the previous 14 years and who satisfies other qualifications as specified in 3rd schedule of the Act. And fifth one is citizenship by acquiring territory. If a new territory becomes part of India, the government specifies the persons of that territory who shall be citizens of India. So now we look at Citizenship Amendment Bill 2019. It amends the Citizenship Act 1955 to make illegal migrants who are Hindus, Sikhs, Buddhists, Jains, Parsis and Christians who are from Afghanistan, Bangladesh and Pakistan who came here before December 31st, 2014 are eligible for citizenship. But the Citizenship Act 1955, that is the original one, prohibits illegal migrants acquiring Indian citizenship. It also proposes to reduce the minimum years of residency in India to apply for citizenship from 12 years to 7 years for such migrants. The bill also provides that the registration of overseas citizens of India cardholders may be cancelled if they violate any law of the country. And OCA persons are who are given a lifetime visa status. The bill will apply to all states and union territories of the country. So what government says about this bill? Government says that many persons of Indian origin, including persons belonging to 6 minority communities from Afghanistan, Pakistan and Bangladesh have been unsuccessfully applying for citizenship under the Citizenship Act 1955 as they are unable to produce proof of their Indian origin. So they are forced to apply for citizenship by naturalization, which prescribes 12 years residency as qualification. Such a long drawn process denies illegal migrants from these 6 minority communities of these 3 nations and many opportunities and advantages that may accrue to only citizens of India, even though they are likely to stay in India permanently. This Act provides a sanctuary for religious minorities who are facing persecution or fear of persecution at their homelands and are being forced to seek shelter in India. These religious minorities were earlier given a special dispensation for grant of long-term visas. This burden will be shared by the entire country, with the centre willing to help to implement it. Government also says that Indian citizenship would not be granted to any foreigner without the consent of the state governments concerned after the passage of the bill. Every application of Indian citizenship will be inquired by Deputy Commissioner or District Magistrate concerned, who will carry out due diligence and submit it to the state governments concerned. The state government also has to conduct an inquiry through its agencies, and only then an individual will be granted Indian nationality. Those migrants will also have to prove that they belong to any of these three countries and were persecuted on religious lines, among other things, for Indian citizenship. Government also promises the ethnic Assamese to look into the Assam Accord of 1985 and Clause 6 to ensure that their linguistic and cultural identity will be safeguarded. So then why protest? A large section of people and organizations in Northeast have opposed the bill, saying that it will nullify the consensus and provisions of the Assam movement and the Assam Accord of 1985 that defined Assam as an ethnic and linguistic region whose character was threatened by migration. Post-accord, due to the insertion of Section 6A in Citizenship Act 1955, the cut-off date for citizenship in Assam is 25 March 1971, and that is the date when the Bangladesh Liberation War started. But the proposed bill seeks to extend this to 31st December 2014. Protesters also believe that the implementation of Clause 6 is an effort to mislead the people before pushing the Citizenship Amendment Bill. They say that the bill has already divided residents of Brahmaputra Valley, who are mostly anti-bill, and Barak Valley, who are pro-bill. Also, nearly 40 lakh people face exclusion from the upgraded NRC, and the proposed amendment will make it easy for the Hindus among them to acquire citizenship. By distinguishing illegal immigrants on the basis of religion, the proposed law goes against the fundamental right to equality under Article 14. So what is National Register of Citizens, or simply NRC? NRC was instituted in 1951, especially for Assam, keeping in view the state's worries over its changing demographics. NRC is purely the list of Indian citizens in Assam. It is being updated to weed out illegal immigration from Bangladesh and neighbouring regions, following a Supreme Court's order in 2013. For a person's name to be included in updated NRC 2018, he or she will have to furnish, first, the existence of name in legacy data, 2, providing linkage with a person whose name appears in legacy data. And what is legacy data? This legacy data is the collective list of NRC data of 1951 and the electoral rolls up to the midnight of 24th March 1971. Out of the 40 lakh aspirants who have been left out includes illegal immigrants, D voters or simply doubtful voters, descendants of D voters, and persons whose cases are pending before the Foreigners Tribunal, etc. So what is the importance of Clause 6? Government says that the Assam Accord 1985 and its Clause 6 was not fully implemented in the state. To weed out migrants, the Assam Accord was signed in 1985, which says anyone who entered the state after 1971 would be considered an illegal resident. Clause 6 was inserted to safeguard the socio-political rights and culture of the indigenous people of Assam. And this safeguard means reservation of electoral seats, land and political rights, rights over natural resources, protection of culture of indigenous people, and introduction of inner line permit system. This is something which the rest of northeast states already have. Doing this, that is implementation of Clause 6, means giving scheduled tribe status to 6 OBC classes in Assam, like T tribes or Adivasis, Thai Ahoms, Chutia, Moran, Motoks, and Koch Rajbongshis. A separate bill would be brought to grant ST status to Bodo Kacharis in hill districts of Assam and Karbis in rest of Assam. According to 2011 census, Assam has around 4 million tribals, that account for 13% of state's 31 million population. And as and when these 6 OBC minorities are extended ST status, the state's tribal population is expected to rise to 54% of total population. Also, 6th schedule of the constitution will be amended to strengthen the autonomous district councils. So what are the issues in this bill? It actually violates right to equality or Article 14 because it seeks to grant citizenship to illegal migrants on the basis of religion. It fails the test of reasonability contained in Article 14. This is because it does not provide any concrete reasons for limiting eligibility of citizenship to 6 minorities of only 3 countries. For example, Rohingya Muslims from Myanmar, Ahmadiyya and Shia Muslims from Pakistan, and Uyghur Muslims from China or who face religious persecution have been overlooked. Second, it is against the basic structure of constitution. Critics argue that the bill undermines secularism, and as secularism is a basic structure which has been reiterated by Supreme Court in SR Bommal versus Union of India 1994. It violates Assam Accord and thus Clause 6 because Accord fixed March 25, 1971 as the cutoff date for granting citizenship to Bangladeshi migrants in Assam, but the bill changed this to December 31, 2014. It conflicts with NRC. Here also date is the issue because in the ongoing NRC updates in Assam, the cutoff date is March 25, 1971 and for the bill the cutoff date is 31st December 2014. Next, the bill fails on the tenets of international refugee law. Although India is not a signatory to the 1951 UN Refugee Convention, granting refuge based on humanitarian considerations is arguably a norm of customary international law. The bill considers persecuted minorities as migrants, whereas word migration refers to the voluntary movement of people, primarily for better economic prospects. Contrarily, refuge is an involuntary act of forced movement. Another concern is about insurgency. The northeastern states have vehemently opposed the bill over the concerns that citizenship to illegal migrants would pose a threat to their cultural and linguistic identity and put a strain on resources and economic opportunities. It is also a violation of United Nations Declaration on the Rights of Indigenous People or UNDRIP because this bill particularly violates Clause 1 of the declaration, which states that indigenous peoples and individuals have the right not to be subjected to forced assimilation or destruction of their culture. Also, a major concern is that Bangladesh's communal and fundamentalist force will be more inspired to drive away the minorities with a view to grab their land and properties even without any compensation. So, we are moving on to the ways forward. And the first one is that bill is beneficial for many communities like Chakmas and Hajongs of Bangladesh and etc. These Chakmas and Hajongs are who displaced because of construction of Kaptai Dam and they continue to be refugees since almost 65 years. But they are also not listed. So, government should try to include other minorities from around the areas too. Second, it would have been appropriate if the bill had used the term persecuted minorities instead of listing out non-Muslim minorities in these 3 countries. This would have been in conformity with the spirit of religious and linguistic rights of minorities guaranteed under our constitution. Next, government should find answers for the questions like what to do with people who will be declared stateless, how to address the concerns without a disproportionate burden falling on Assam and so on. Also, India should not get confused between a migrant and a refugee. Insensitivity towards refugee in times of global migrant crisis will only be unethical to India's belief of Vasudhaiva Kudumbakam. Giving a concession of 5 years for residents based only on religion is against the tenets of secularism. This should be dropped to stand the test of basic structure doctrine. Also, government should also formulate policies and take appropriate measures to provide education, employment and a decent living to the concerned migrants. The government should take necessary steps to assure that the rights and socio-cultural identity of indigenous people is not affected. The government must introduce a legal framework for asylum and a pathway to citizenship for asylum seekers in compliance with the United Nations Refugee Convention of 1951. Such a system would be fair, humane and non-discriminatory. So, as a conclusion note, in this globalizing world, India supports unrestricted movement of natural people across borders. So, India should make it easy for everyone without any differentiation who are born in India or has been resident in India for a reasonable period of time to acquire Indian citizenship. Also, identity is a sensitive issue in Assam and the government must tread carefully so that the delicate peace prevailing for the last 2 decades is not disturbed. That's all, and thanks for watching.